All right, everyone. I hope you're having a great day. My name is Angie Holloway, and I am the lawyer for doctors. And in this short 15-minute or less video, we're going to talk about how to start your own direct pay medical practice and everything you need to know to make sure you start out on the right foot. All right, so let's go ahead and get into it. What are we talking about today? We're going to talk about first, what is a direct pay practice? Second, what are some common mistakes that many people make with respect to business structure, contracts, and compliance? And lastly, I'm going to give you guys a freebie to download the checklist to audit the patient contract that you're using today. For those of you who do not know me, I am Angie Holloway, the lawyer for doctors, and I help top Georgia medical practices protect their licenses, their practice, and their peace with concierge legal expertise. So I've been practicing law for a little over 8 years now, and I've represented individuals and corporations all over the state in both state and federal courts. I've sued big corporations like Walmart, the federal government, state governments, and now I spend all of my time helping my clients avoid court altogether. Okay, so let's talk about it. What is a direct pay practice? A direct pay, or sometimes called a cash pay or a concierge type of practice, is a specialty practice where you are not going to be accepting insurance or any type of payer contracts from a third party. And so basically, what you're doing in a direct pay practice is that you are getting your compensation directly from the patient. And so you have whatever that agreement is, that doctor-patient contract that you're going to be utilizing so that you can make sure that you get paid for your expertise and your medical services. So let's talk about, why is direct pay a growing trend, right? So for doctors and medical practices, the reason why this is a huge trend is, the first one is huge accounts receivables, or sometimes they're called ARs. And basically what that means is the amount of money you're waiting to receive from services that you've already rendered, right? So I've spoken with several of my clients who've had accounts receivables that were hundreds of thousands of dollars. Just a few weeks ago, one of my clients told me that he had an accounts receivable of over $500,000. And so within that AR account, you have a series of different services that you provided that may be from 2 months all the way up to 2 years ago. And so these huge accounts receivables are basically creating cash flow problems for these small practices. And so you're hoping and praying that the insurance company will ultimately pay you, but these payer contracts and the way that they process them and the appeals and the administrative burdens, all of these things provide a very long payment cycle for medical practice owners. The second reason is declined payouts. So sometimes you'll provide the service, maybe you received prior authorization, you expected to get whatever that small percentage was. However, you just didn't get it. They declined it, and maybe it's not worth the effort for you to invest either the time or your staff's time in order to go through the appeals process. So declined payouts is a huge reason why many are transitioning away from insurance-based practices. Number three is decreased payouts. So as far as the amount of money that you're actually receiving from an insurance provider, normally that ranges from as little to single digits. I've seen situations where clients, particularly in the mental health space, psychiatrists, psychologists, therapists, who may receive something as small as a $9 payout for a Medicare or Medicaid patient. And of course, that depends upon what the insurance payer contract provides, but they're very, very low as compared to what you would get on the private market. So the amount of money that you actually receive after you wait for this extended 6-month, 12-month, 24-month period, it's just not worth the time that you spend with the patient or the series of patients based upon the actual return that you get. And lastly, you have really, really high patient caseloads. And so what that means is most people are only being able to spend, especially in the doctor space or the physician space, you have 8 to 15 minutes with a patient. You're heavily relying on support staff, nurses, or advanced nurse practitioners, and things like that in order to be able to manage several hundred patients at one time. it may take, several months for a patient to be able to see you and get the care that they need. And then they may be relying on urgent care or emergency care services because they're not able to see you on a regular basis. And so, for all of these reasons put together, many doctors are choosing to decline to accept insurance altogether and to just have a direct pay or concierge type of relationship with their patients. For patients, the things that are making this very attractive is first, concierge services. People appreciate being able to see their doctor with shorter time periods. They don't want to have to wait 6 to 8 months to be able to get on their calendar. They are tired of having to deal with all of the insurance loopholes and back and forth, right? So you have a copay and you have deductibles and then you have exceptions, and people are appreciating transparency and price transparency. And so when you have a concierge practice, people appreciate knowing I'm going to pay this set price or I'm going to pay this subscription model, and not having to do the whole rigmarole with insurance companies. And lastly, there is a shift in people wanting to prioritize well-being and wellness. And so creating the kind of team that you need, whether that be therapy, mental health services, physical therapy, primary care, all of those things working together, they want to be able to do that in a way that serves them, where they don't feel like they're being unheard and unlistened to. So, for all of these reasons put together, direct pay is a growing trend. All right, so let's talk about the legal implications for a direct pay practice. So, these are some of the top three things that are really important for you to consider as you are starting this cash pay practice. The first one is your patient contract. Okay, so because you are not going to be using that payer or that third party or that insurance practitioner, you are going to have to make sure that your patient contract is airtight, right? So there is no middleman to protect you or to go after or for an employer to pay, right? It's between you and your patient, right? So that is provides a lot of transparency and also an opportunity for connection, but there's also a risk component that has to be mitigated, right? So you need to think about, okay, chargebacks. Okay, what if someone signs up for a plan for 6 months, but then they want to terminate, right? There's all of these different nuances that you have to consider that you probably weren't considering in the insurance-based practice because you were just depending on those payouts, right? And so having a very strongly drafted patient contract is going to be kind of that first line of defense for you in protecting your practice. It also helps you with mitigating opportunities for lawsuits or grievances, making sure that your patient contract addresses all of those issues, as well as like practice specific area requirements and regulations that apply to your specific practice area. All right, number two, your risk profile. So your risk profile can be higher with small practices. So when you're in a larger practice, whether that's a physician or maybe you're in a PT practice or you're in a mental health practice, typically the risk profile is distributed among the different providers. Okay, so if you have a small physical therapy practice, for example, and there's going to be 10 practitioners, right? 10 physical therapists providing care, right? So when you get the actual policy, they're going to consider the fact that it's not just a sole person. You're going to have 10 different individuals that you can distribute that risk profile among, right? So if you're a solo practitioner or you only have one or two people, then the risk is going to be concentrated for those individuals instead of it being able to be distributed. So that's something to think about as far as with your insurance indemnification and making sure that the individuals who are running the practice or even your support staff, a mistake that they make could have huge consequences because of the limited amount of people that are in your actual practice. And number three is compliance obligations can bankrupt your practice. So if you're not a huge provider like one of these big like Wellstar or Piedmont, you don't have these huge teams and you don't have maybe the budget to do compliance protocols to the extent that these companies are doing them, right? So one of the things you want to think about is making sure that your compliance program is going to ensure that you're not going to be susceptible to HIPAA fines or Department of Labor fines or wrongful termination lawsuits because you do not have the bandwidth in order to be able to afford these types of large lawsuits or risks to your business. And so making sure that you have all of these things in line, making sure you have adequate insurance for workers' comp, making sure that you have proper non-competes in your employment contracts, making sure that you have a HIPAA training regimen, right? For all of the individuals who are in your practice, all of these things are foundational to make sure that you're not going to be exposed to a multi-million dollar fine or lawsuit for malpractice. All right, so let's talk about some of the most common pitfalls that I see. So we've kind of talked a little bit already about missing compliance. So I don't want to go too much into that, but we also have HIPAA, the Stark Law. FTC is dealing with advertising requirements and making sure that you aren't falsely advertising or misrepresenting the benefits of examples, some things that you might be selling, vitamins or things of that nature. Georgia Medical Board, and others. So whatever your regulatory agency is, depending upon your medical specialty, making sure that you as well as your staff are complying with all of those requirements. And we've talked about wrongful termination and non-competes, proper categorization of staff. So there is typically a strong preference for people to classify workers as 1099s because it comes with less overhead, and as far as compliance is concerned, it's a lot less, right? So the 1099, you don't have to worry about paying those wage fees that are associated with employees. Okay, so a lot of people want to do it because it's easier, but in 2022, the laws changed in Georgia. And so now there is a presumption that most individuals are going to be an employee unless an exception applies. And lastly, medical malpractice. Obviously, it's really important, particularly when in the physician space, a lot of the actual insurance costs are prohibitive for smaller practices. So you want to make sure that all the other things that you're doing to make sure that you mitigate your risks are in place. Okay, so let's talk a little bit about contract mistakes. So the first one that I see is free online templates. So these free direct pay templates that I see that are often passed around in the community, they, first of all, a lot of times have outdated clauses and the wrong law, right? So of course, everything is dependent upon your medical specialty and the law is constantly changing, right? So there's new cases that come out, new precedent that is set. And so as those things change, your contracts need to be updated accordingly. One of the most important things is that they're just missing a whole lot of provisions that would protect your practice, right? They don't anticipate risks, right? So there's all of these different gray areas, for example, that may come up in your business. For example, in the mental health space, right? So creating boundaries such that you're providing services to the person, therapy, supportive services, but making sure that you're not doing it in a way where it compromises your boundaries, right? And so one of the things to think about in a therapy contract as opposed to a med spa contract would be, what are the expectations? What are the appropriate levels of care given what their diagnoses are, right? And so if those diagnoses change or if they're not compliant with their medication, what are your discharge protocols, right? So there's all these different nuances that have to be considered when you're thinking about a contract. It's not just words on the page, it's how are we going to govern our professional relationship? What happens if things go left, right? How do I terminate my relationship without violating the ethics of my regulatory agency? And then also creating a relationship where the patient is getting what they need, but you're also getting what you need as the therapist, right? So all of these different nuances, making sure you have defined terms. That's one of the things I see very often is you're using terms of art that you're familiar with, but the patient is not, right? And so if you don't define that word, now you have confusion. Now you have an opportunity for a chargeback, a bad review, any number of things that can happen. And so making sure that the expectations are set at the outset, what you expect from the patient, what you're going to be providing to the patient. In layman's terms, it can go a long way to developing rapport with that patient. The second thing I want to talk a little bit about is business formation, right? So everyone loves LLCs, and that is one of the easier business formations to manage. However, sometimes it's not the best option when choosing a business structure. So sometimes a professional corporation is better, right? Because the actual bylaw requirements for professional corporations require that everyone maintain whatever that license is, right? So maybe you have a group of physicians who are forming a DPC practice, and they're going to each have a different level of shareholder interest within that, right? So let's say, for instance, one of the four physicians loses their license or their license is suspended. In accordance with the professional corporate laws in Georgia, that person would have to no longer be a shareholder, and there has to be a procedure upon which you're going to buy back that person's interest. They would only have a financial interest at that point, right? And so there's all these different nuances that would make more sense versus in an LLC, you don't have that level of structure, but of course you could put that within your operating agreement as opposed to your bylaws. And so making sure that when you start that business relationship, you guys are really thinking about your exit strategy. And although it's not a fun thing to talk about, you don't want to be in a situation where you're having to have that conversation after there's been some form of huge disagreement where people aren't willing to come to the table. So business formation is a really, really important, particularly when you have partners or other people, or you want to take on investors, making sure that you're drafting it in such a way where you can protect your interests as well as the other members. All right. So, what do I do to help you start your new practice? So, I create a custom strategy based upon what your medical specialty is, whether you have partners or not, how we need to go about forming your business, your commercial lease, whether or not you're going to be doing virtual if you're a mental health provider and you want to provide, e-therapy, or if you're going to be doing a DPC practice and you need to get your commercial space before you can get your DEA license and registration. So all of these things are dependent upon what your medical specialty is. When we have a conversation, it's called a Start My Practice session. And what you can do is schedule that directly on our website, and we'll talk about what you need to do in order to create your practice with suggested timelines and next steps. So if you are already having, if you already have a medical practice and you're wondering if the template that you have has all the necessary clauses that you need, I would encourage you to download our Audit Your Patient Contract Checklist. It has the top 10 clauses that you should have in your patient agreement. And you can figure out in 10 minutes or less whether or not you should consult with an experienced business healthcare lawyer. Thank you so much for watching. And again, my name is Angie Holloway. I am the lawyer for doctors. I will drop within the description the links directly to get these freebies or to book a call directly with myself or a free fit call with a member of my team. Talk soon. Bye-bye.